Hi. Oh, let me just click on this. Right. So, as Maya mentioned, my name is Imran Daniel, and I have actually been this year, would have been 20 years that I'm involved in the insurance industry. And basically, what I do or where I work is a place called Genesis Insurance Brokers, which is an insurance broker for all type of insurances. So basically, I started out working for a single insurer, which was British American Insurance. And then I went into the broking side of business. So for those who don't know, when you work for a single insurer, all you could offer is what they offer. So say, for example, a Guardian Life or a Sagicor, all you could look at is their products and offer it to somebody else. Whereas with insurance broking, you get to look at the entire market and then decide what is best for somebody else. So I mentioned that because my son is now 8 years old and he was diagnosed when he was almost 4 years old. And obviously the topic of insurance and autism came up. And it's something that I've been looking into for a while, and I spoke to Dr. Mays about it. And she decided that now would be a good time to talk to parents about it because we get a lot of traction in the WhatsApp groups and on Facebook and whatnot. And parents really concerned about what they could do for their kids on the spectrum. You know, especially on the whole, of course, we know lacks a lot of infrastructure all over the country. And the insurance aspect is almost similar in that aspect, you know. So basically, I'm here to talk about what can possibly happen or what you could possibly do for your child on the spectrum when it comes to insurance, right? Anybody has any questions in between, please, well, I guess raise your hand or ask the question. It's better to ask it one time and we go on and we have to come back to it, right? So basically, the first question people ask is, can my child with autism get onto an insurance plan as a dependent of mine? The answer, it's not straightforward. And unfortunately, most of the times the answer is no. So while I'm mentioning that is that the fact is that insurers are not up to date or are not educated enough, the underwriters, I should say, of the insurance companies, to look at these cases on a case-by-case basis or one-on-one basis. What they do is that initially when somebody signs up for, say, health insurance or life insurance, there are medical questions that they ask. And one of the questions is, does anybody on this plan have a mental disorder? Now, as we all know, autism is not a mental disorder. It's a neurological disorder, and classing the two together is simply incorrect because somebody with autism can have proper mental health and continue to function as normal as they go along through life. So what they basically do is that they class everybody in one pool. And if you have autism, no matter the spectrum, no matter where you are, wherever it is, they class all as one. So mild, moderate, severe, they class everybody the same way. And we have had constant battles with insurance companies about having children with autism added to these plans, right? What I told somebody the other day was that the cost of a the assessment, we all know it's expensive, right? Say, for example, an assessment is $6,000, right? That's a one-off cost for an assessment to find out where the child is at, right? This $6,000 is not going to wreck any insurance plan. The $6,000 that you are claiming for an assessment for a child with autism pales in comparison to the guy who has a cancer case going on for the last 5 years, or a diabetic, or somebody's hypertensive, right? So these are things that me especially constantly bombards the insurance companies I deal with as to why it's not covered, right? So this is for individual applications only. They will class your child, or if you are a guardian, as being uninsurable, and they will tell you outright that no, the child cannot be covered. However, if the child goes onto a group health plan, so individual plans are basically one set of standards, one set of rules, one set of benefits for everybody across the board. There's no alterations. If everybody has an individual plan, everybody has the same benefits and the same pricing regardless of where you fall. With group health plans in Trinidad, group health plans are made up of companies forming plans for their members or employees, whatever the case is. They could range from 3 persons to 300, right? What they do is that, oh, somebody has a question? Oh, sorry, no, right. So what they do is that they can alter benefits to suit their employees and what they need. So we have international clients who specifically ask for coverage like this with autism. And the insurance company said, no problem, we could put it in, you'll have to pay the extra, whatever the case is, but the point is that they can put it in, right? So my advice to anybody who is on a group health plan or work somewhere where your company offers group health insurance, if it is the only way your child could get onto that, it's say, for example, what happens is that if you are working, say, company A, and your child is born, say, today or tomorrow, you have 30 days to add this newborn child to your plan with no questions asked. Obviously, you would not know from the time the child is born if they will fall on the spectrum or not. But say later down the line they do. The insurance company has every reason to cover your child, regardless of what, because they were able to come onto the plan within 30 days after the child is born, right? These are the loopholes and these are the ways that you could get through it onto the plan and whatnot without having to fill out the forms that these companies ask for. So it's never a straightforward answer as to what I could do now. It's always to try and find a way around the system. The system, of course, as we know, is not specifically helpful to our kids who are on the spectrum. And that's why we have to find ways and means to go around it. And of course, because I am in the frying pot as well as the rest of you all, I am looking at all these loopholes and trying to find ways to get kids like this on the plan. It's nothing short of me now actually writing to the insurance companies or basically have pediatricians who are knowledgeable enough to write to these insurance companies. We don't know, but my advice to parents here listening is that look, if you have a plan where you work, look and see what that plan offers. Ask the person in charge of the plan, who will be known as your either HR person or plan administrator. My child has autism. Are they covered? What are they covered for? You know, it's always good to look at those things. The other aspect is that maybe if you're in a credit union, for example, credit unions have medical plans. Ask somebody there what they offer. You know, would my child be able to get onto this plan? What are the benefits? You know, you will have to do some searching yourself. I mean, anybody can message me after and find out about these things. I am very willing to give what advice I can and try and guide you all accordingly. But the stark reality about insurance and kids with autism, it is another battle that us parents and guardians have to fight. And it's something I plan to actually continue fighting with the insurers about, you know, because there are, as we know in Trinidad, it only affects people when it affects somebody in authority. And we have very large insurance companies that actually have influential people who have kids or who knows somebody with kids with autism and on the spectrum. They are influential at their jobs in the community, and they would be the ones that should be championing this cause. Because at the end of the day, who is Imran Daniel to ask a large insurance company to add this as a benefit? You know? So it's another one of those things that is not cut and dry. I couldn't come here today to say outright that sure, your child will be covered. This is also for other special needs kids, not just kids with autism. And as I mentioned, it's an ongoing issue. And I'm hoping that probably one day they might really look exactly what the wording is, because in cases like this, when you try to add your child to these plans, the insurers suddenly use the contracts and they use words in the contracts. So, I mean, I'll have to talk to Dr. Mahes because I have some ideas about how we could go about this writing to these companies. Because like I mentioned earlier, the cost of a child going for therapy once a week is not even relatable to the serious medical illnesses that we have all over the country. You know, so why single out these children and brand them as something that they are not? You know, so like I mentioned, anybody want to reach out to me to ask any further questions about it or find out what else could be done, I am available on WhatsApp or phone call. So that is the end of my brief presentation, and I hope it made some sense. So over to Maya.
Thank you so much for that, Imran. And well, as Imran said, you all could message him for more information and he'd be happy to help. So now I'd like to pass it on to Denelle.
Hi, good afternoon, everyone. My name is Denelle Singh. I am an attorney at law. I have been practicing for the last 5.5 years at the Bar of Trinidad and Tobago. I have worked at the Children's Authority of Trinidad and Tobago, and I only just recently left, so I do have a lot of experience with family and children law. I am also an executive member of Facilitators and TNT, and it is a pleasure to be here today with you to spread some information, spread some awareness as to what you all can do as parents to essentially plan for your future. So I'll just jump straight into my presentation today. One sec. Can everybody see my screen? I assume everybody could, right? All right, so we're planning for your child's future from a legal perspective. So what does that mean? What are we going to do? What are some of the things on our mind? So any questions you'll have, you feel free to ask in the chat, or you can ask after the presentation. Just let me know. So you're thinking to yourself, okay, so what's gonna happen to my child when I'm gone? Who am I gonna trust to take care of my child? And we know this is a big issue because trusting someone to handle this job when you're gone, it's a huge decision, and it's a big decision because you're essentially putting somebody else in charge of your child after you're gone. Single parents, if there are any, I don't want you all to assume that the person who is assisting you, whether it be your mother, your aunt, your sister, and uncle, as the case may be, don't assume that person helping you is automatically going to get legal custody of your child after you're gone. They also have another parent in the picture. If that parent is still alive, that is something to consider, that that parent also has something that we call equal parental rights. So who is considered a child, right? I know there are some confusion about exactly the definition of a child. There are persons who believe that a child is still somebody who is under the age of 16. However, that law would have recently changed, and a child is now anyone under the age of 18 years of age. Something I know a lot of parents who may consider with children who are not as high functioning on the spectrum, you are now tasked with caring for your child who may operate mentally as a child but legally an adult. So your 25-year-old child, you're 25 legally, but you also operating at the mental capacity of, let's say, a 10-year-old. The law does not cover for the mental capacity, the mental age of a person. So once you are 18 years of age, you're considered an adult. That's just a point to note, right? So how do you go about planning for your child's future? And the easiest way are via wills. And it's a legal document essentially outlining your wishes for after your death. It essentially deals with your intentions, what you would like to happen after you die. So this is in relation to your assets, to your jewelry, to your money, as well as to your children. That power, and I must touch on this point, if you do have joint accounts, the law of survivorship says that it automatically passes to the remaining party. So that's a point to note as well. I know we're focusing on your aspect of the children, but that's just something I wanted to mention. The will essentially gives the powers and the duty to an executor to specifically administrate your estate and basically distribute it in accordance with the specifications in your will. So what are the requirements of a will? So basically it must be in writing. The person making the will, you must have something what we call testamentary capacity. That is the ability and the mental capacity to make decisions regarding your assets. So you're not doing this under duress. Nobody's forcing you to do this will and leave them your piece of land, essentially, right? You must have sound mind in order to prepare your will. You must appoint an executor. And this is the person who will be in charge, like I mentioned, of carrying out the wishes of the deceased person. The law allows for a maximum of 4 executors. However, we do advise persons to at least appoint 2. So in the event that one person dies, the other person can pick it up. However, if both happen to pass away before you and you don't get a chance to update your will, the probate law will set out a particular method as to what is to happen. And you can always consult an attorney if that applies to you as well. Deciding on your executor is an important decision because it requires trust in that person to carry out your wishes and act properly on your behalf. So definitely have a conversation with that person that you want to be the executor of your estate, because they are also responsible financially for the estate until it can be distributed. So they will essentially be responsible for the legal fees, for the searches that have to be done on your estate before you actually get that grant and you're able to properly administer your estate. So it is an important rule, and it's not one that should be taken lightly. A lot of persons misconstrue the meaning of an executor, thinking that if they appoint this one person, that person is essentially going to have control over who gets what. That's not what happens at all. You get to make that decision on your own. There is also as well what we call a residue clause in the will that you can put in to account for your assets that are not specifically mentioned in your will as well. So let's say that you make your will today, but tomorrow you acquire a vehicle. So that residuary clause will capture the vehicle and who you would want the residue of your estate to go to. So that's also an important clause to put into your will as well. Your will also, in order for your will to be valid, it also has to be witnessed by 2 independent persons, meaning it can't be your executor and it can't be any of the beneficiaries. So it has to be 2 independent persons who aren't entitled to a share in your estate. So when is the right time to make a will? And I find a lot of persons ask this question, okay, so when do I make a will? Do you wait till you get older? The answer is no. As soon as you can, because you can amend your will at any time. So you can make your will today at 6 p.m. and tomorrow morning, if you get up and you decide you want to make a change, you can make that change accordingly. And the document that is the latest will take precedence essentially. So what happened, especially during COVID, is that when a lot of persons, unfortunately, succumb to this virus, many of them would have died probably without a will, and it could have been on any age. Now, we know from that anything can happen to anybody at any time. So are you too young to have a will? The answer is essentially no. Writing down whatever you want to happen after you die is always important. Have that conversation with persons. We have many young parents out there as well, many young persons who may have some assets to their name. And even if you don't have an asset, and let's just say that you have something that you want done after, make a will and have that done. So avoid uncertainty in your will as well. I would definitely advise that you describe your assets as clearly as possible. Put the details of your child's care in writing. So essentially, if your child is 6 years old, what school you want your child to go to, medical decisions, you are essentially going to have to step into the shoes and decide what is going to happen if I am not here to take care of my child in the event that X, Y, and Z happens. Who's going to be making the medical decisions? What would you want as a parent? You can have that conversation with the person you want to leave your child to, and also put that in your will as well. So essentially what it is that you're going to do, you're going to write down all your assets and all your wishes, talk to your family members and trusted friends as to, who will take up this responsibility to properly care for your child, who you want to care for your child. Get advice. Ask an attorney for legal guidance if you have any questions. Attorneys are there. Strategy. You're going to think about your child's future. You have to think about every aspect of your child's future and execute it. Prepare your will, put things in place legally. Don't wait around. What is going to happen as well when you wait? Sorry, I'm not I think somebody's writing on the on the screen itself. What's going to happen is that you want to prepare your will and you want to put things in place legally, because if you die unexpectedly, you're putting a lot of unnecessary stress on the persons who are left now to administer your estate now in what we call accordance to law, right? You could create conflicts as well. I can't speak to every particular situation, but we do know of situations where the person dies and there's no will in place, and now family members suddenly think, well, I was taking care of this person for however long, so I have more of a entitlement to this asset than this person. Even though a parent may say to a child, well, hey, this is for you after I die, that is not in writing, and you have other siblings, that is something the law has to consider. It will divide equally. So always, it's not too late. Prepare your will, put things in place legally. So some points to note in relation to the child aspect, because I know that's of particular interest to us, especially for special needs kids. The right of the surviving parent, right? So on the death of a parent of a minor, the surviving parent will automatically be the guardian of the child, either alone or jointly with any guardian appointed by the deceased parent, which can be done via a will. Once that is done, once you have a document that says, in the will, you're leaving your child to this guardian, you want this person to be the guardian of your child, and that is in your will, and the grant is obtained, you can now apply to the court and obtain an order. That guardian appointed will now be able to obtain a court order, so they'll be able to act on your child's behalf. Where no guardian has been appointed by the deceased parent, or if the person appointed has either died or they refuse to act, the court can now step in, and if they think fit, appoint a guardian to act jointly with the surviving parent. The surviving parent does not need to necessarily act alone. They can act alone, but if they can't, the court has the power to appoint a guardian jointly with that person. And this comes into play in a lot of circumstances where the surviving parent may not have had custody, may not have had joint custody, may be living in a different jurisdiction as well. What the court thinks as fit and proper comes down to the evidence. You just have to be able to properly care for the minor, and the law accounts for what we call the best interest of the child and the welfare of the child, and different factors to consider to each circumstance. I'm seeing some questions in the chat. I will get to them in a bit, right? So parental rights again. So how are you as a parent going to leave a guardian of your child? So that can be done by deed or by will. It's mostly done by a will. You can appoint any person to be the guardian of your minor after your death. The guardian now will act jointly with either parent, as the case may be, as long as the parent is alive, unless they object to the guardian acting. Now, if the surviving parent objects to the guardian acting jointly with them, he or she will now have to go to court and carry that issue to court, and the court will have to make a determination on those issues. So where there's no parent or guardian appointed. So let's say you're the sole surviving parent of this child, you have not appointed a guardian, there's no other person having parental rights, no other person you have legally appointed, any other family member, any other close friend. Once you are fit and proper, and once the court thinks so, that person can be appointed to be the guardian of your child. But like I said in the beginning, you don't want to put that unnecessary burden or unnecessary conflict between the persons you're leaving behind. So the advice remains: prepare well, prepare for the inevitable. Talk to your family members, your spouse, close friends on caring for your child. Married couples, have that conversation about, if either one of us were to die, do you want to take care of the child alone? Do you want somebody appointed with you to care for your child? And in the event of anything and any other further questions, definitely consult an attorney. So at this time, I will open the floor for any questions you all may have. You can just turn on your mic and feel free to share. I saw one question in the chat of the estimated price for a will. Attorneys charge basically per hour. It depends on the complexity of the will, but it's roughly about $1,000 to $1,500, if so much. It depends on where you go as well. I'm seeing some hands raised, so okay, go ahead. I think we have any questions, Maya.
Hello.
I see Kat has.
Right.
Yes, I have my hand up. Right. I have two questions based on two scenarios, which I consider to be realistic scenarios. The first one is this. Suppose a parent has full custody while they're alive of their child. They die, but they've made a will saying, okay, their sister is going to take over care of your child with special needs. Can the parent who does not have full custody challenge that will? That's the first question. And the second question is this. Suppose a parent makes a will, and they will everything to the child who is neurotypical or doesn't have autism or any other disability. Can that will be challenged? So say they have a house and the parent has left the house to the sibling that does not have disabilities. Can that be challenged on behalf of the child because they probably will end up homeless or something like that? So those are my two questions. I hope they make sense, but ask clarification if you need. Thank you.
No problem. So I'll take your first question. In relation to challenging the will in the first instance, the straight out answer is no, that surviving parent cannot challenge the will. What they are going to probably challenge is the aspect of the appointment of the sister as the guardian. But once you have that in your will, once your will is properly probated and the executor has a grant of probate, they are now trusted, like I said before, to carry out the wishes of the will. Once your will is valid, and let's say your sister is now in a position to have guardianship or custody of the child, the surviving parent, yes, they can challenge it, but it will come down to a court of law hearing evidence from both parties, from the surviving parent as well as the guardian, and they will make a determination whether the persons act jointly, or the sister would act solely and be solely responsible for your child. Parental rights remain. Even though you have full custody of your child, parental rights are still intact. They're not severed. So I hope I answered that first question. It will really and truly come down to a court of law making that determination if the parent is to challenge it. And the short answer is yes, it can be challenged. The will can't be challenged unless it's some other aspect that calls the will into question. But you appointing your sister via will can't be challenged. What would essentially be challenged is who's going to be the guardian of the child at the end of the day in the court. In relation to the second question, yes, you can leave the house to the child who has special needs, and you indicate in the will as well that this is your reasoning behind it. Then if the surviving sibling who does not have special needs wants to challenge the contents of the will, they will have to carry it to court, and a court will have to make the determination on whether the will is valid, whether the clause left in the will is valid, and whether what was the true intention of the will, what was the true intention of the deceased person. That's what will come down to. Anybody who wishes to challenge a will, it will always have to end up in court, what we call contentious probate. It ends up for a court to determine the issue, because it will have many other factors in play. For instance, in the first situation, where you're appointing your sister as the guardian, your sister's evidence could be, and I'm just saying hypothetically, can be that they have assisted you in caring. They have seen how you care for your child. They have experience in caring for your child. They have a bond with your child, as opposed to the surviving parent who probably has access to the child every 2 weeks, who doesn't maintain the child financially. It comes down to evidence based, and it comes down to the welfare and the best interest of the child always at the end of the day. I hope that answered your question.
Thank you for the answer. You answered the second question was not what I asked, but was your response was valid anyway. To clarify, my second question was, if you have, say, 2 children, one has got autism, one does not. The parent wills the house that they all live in to the child that does not have autism. So basically, the child who has autism, I guess, could be put out the house or whatever. Can somebody challenge that will on behalf of the child who has autism, who would not probably have the capacity to challenge the will themselves? That was the question.
Yeah, somebody can act on their behalf once they have Lucas, what we call next kin or next of friend. They can act on their behalf. But you're saying to me that the house is being left via will to the child who does not have autism, right?
Yeah, this is hypothetical, okay? This
Yeah.
is not.
No, I understand. You're leaving it to the child who has the sound mental mind. But there are 2 of them living in the house. You can put in a clause in your will, but like I said, you'll have to seek legal advice on it. This is not the forum for me to dispense proper legal advice. Well, dispense legal advice based on hypothetical situation. I mean, I could, but I don't want to do it so broad. I'd prefer that, we discuss the different aspects of it as well, because it could come down to very, very technical points. But a will can always be challenged. It's just on the basis of which it is challenged. If somebody wants to act on behalf of the child who has autism, they can via next of friend application as well.
Okay, thanks a lot, Ms. Singh. You've answered my questions, and I'm very pleased to know that, it can be challenged on behalf of, someone like that. Thank you so much.
No problem. Not sure if we have any other questions for myself or Imran.
So we have come to the end of our session now, but before we conclude, do we have any more questions from anyone?
Hi, yes, I have a question for Imran, please. Imran, you mentioned the insurance and all the problems with insurance, but two questions actually. One, are there any companies now that would actually cover speech therapy or any of the therapies? That's the first question. And the second question is, we do have a lot of parents who are not employed and would not be under any kind of group insurance with their employers and so on. So what options do we have for them to be able to get insurance for themselves and for their children outside of an employer?
All right. To answer the first question, most of the insurance companies, they have therapies that are benefits. Some of these benefits might be speech, occupational therapies, but like I said, it's right just to get onto these plans. So basically, although, well, I don't even know, this ties into the second question. Even if you unemployed, so apparently I'm the bearer of bad news whole evening. So
it's difficult.
Yeah, because you see, like everything else, even if you're not working somewhere to access a group plan, like I mentioned before, places like credit unions and whatnot. But then again, you have to have money to be in the credit union. So that's a whole other thing by itself, you know? It always comes back to if we as parents not able to afford therapies like this, it always comes back to us facing the public health system. And we all know the challenges of that, because we live in an imperfect society that is nowhere perfect for our children, you know? So I'm not sure how it is we could go about how a parent who is unemployed can go about accessing that besides the public healthcare system, which we know takes time and might be woefully inefficient.
Okay, so I have a third question. So how difficult, or what would be the procedure that we would need as a group to, let's say, go to one of the insurance company or go to Genesis Insurance and get a group plan that members, parents from within the NGO, for example, can, not necessarily a group plan, it wouldn't be a group plan, but can advocate on behalf of the members or the parents in the NGO. How difficult is that whole process, and where would we have to start with that?
So for group health plans, they could basically be a company, which is an entity by itself, and then they could have association plans. So for example, Denelle she is attorney at law, and she is employed under the body of LAT. That's correct, right, Denelle, sorry?
Yes,
Right?
that's correct. Yeah.
Correct. So the law association, for example, is made up of 3,500 members. And what they did was they offered all the members of the law association or LAT the option of a group health plan voluntarily. Right? Basically meaning that if you want to join, you can, it's not mandatory. For support autism, something like that, it would have to, because it's an NGO, they might not be able to get the cover, right? It has to be, well, I mean, I shouldn't say that outright. I can look at it because they will look at the directors, they will look at the members. It could be something, but at the end of the day, if it is the insurance companies, they're very contradictory, right? So what happens is that, like I mentioned earlier, so say support autism formulates a plan, right? They're not going to bring on kids on the spectrum onto the plan just like that. So they will deny them, they might accept the parents, but not the child, which will defeat the entire purpose, right? Insurance and kids on the spectrum does not go hand in hand whatsoever, right? So there's no easy answer or no clear answer as to how we could do something like this. Like I mentioned before, I'll have to talk to Radhika about something I had in mind afterwards. But for now, it's a very tricky process. It's a very time-consuming process. And so far, in the experiences we had, it's a very disappointing process. You know, because parents trying their best to look for something like this for the child and getting shut down everywhere they go. You know, but like I said, they might have loopholes here and there. It's just to find it. It is by nowhere absolute straightforward line we could walk here with this.
Okay, I hear you. Thank you.
So there's a question from
Yeah, I'm
Stacey,
seeing a
yeah.
question in the group as well. So,
I think Stacey was somebody other hand. No?
Stacy had her hand up.
Stacey's here still.
Hi, yes, I'm
Oh,
here.
hi. Hi.
Hi, good. I kind of came in the chat a little late, but I
Sure.
think I'm getting a better understanding with regards to the insurance aspect. Really, I just would like to know, is there any, and this, because I wasn't here a little earlier, so bear with me. Is there any insurance that could cover children on the spectrum? That is one. And the second question, which is not with regards to probate, if a relative died, could the existing relatives, they didn't leave a will, could they contest in terms of property, insurance, money, and stuff like that? I know that's kind of like a broad question.
So to answer the first question, as it is now, there are no insurance plans for you applying on your own to add your dependent autistic child right now. As I mentioned earlier, they might have some loopholes to add them onto a group plan, but those things are on a case-by-case basis. And it's something that you have to scratch and claw at to get them on the plan to begin with. So my role here this evening was ready to let parents know that don't get your hopes up when it comes to this. Sadly, is another hurdle that you have to face. And something that, I mean, we could try to advocate for with the right channels. But for now, the answer is outright no. So.
Excuse one other thing with regards to the group plan. What does that entail? Could you just give me a broad idea in terms of?
Sure. Sure. Those plans are for like companies and entities that offer employees or members plans, which is called a group. So instead of you, Stacey, having a plan for you and your family alone, this will be like, say, for everybody on the chat, which is what
Could a non-profit organization apply for such a plan?
I'll have to do some investigation into that. That was the question Radhika asked earlier. But like I said, even if an NGO were to do a plan and they were to start filling out the forms, immediately because of the census of the group and who they're planning to insure, insurers might one outright just deny to quote or deny to offer coverage, or just, I mean, not cover them at all. So you're right between a rock and a hard place here with this.
Thank you.
Sure. And with the second question, yeah.
Right, Stacey, with regards to the second question, where a person does not leave a will and they have died, the law comes into play, what we call the lasses of administration. There are certain requirements which allows for who can apply for your estate, as well as who is entitled to your estate and your property. So your property will have to be distributed in accordance with statute, in accordance with law. The persons applying, it will be your next of kin, who can be your spouse in some instances. If not your spouse, it comes down to parents or siblings, and then your child can also apply. In circumstances where you have one child and that child is a special needs child, the best person to probably apply for the estate will be someone with the mental capacity to do so. And essentially, they will cover that in their affidavit to explain why the child cannot apply. It would be because they don't have the mental capacity to do so.
If that person doesn't have any spouses, parents, or siblings, what next?
No spouse, no parents, no siblings, no children, or just the one child.
Yeah.
Somebody can apply on their behalf. It will come down to essentially like a trustee. It will be like a trustee position, someone applying on behalf of the child and the attorney preparing the application, because it has to be done via an attorney. They will essentially explain in the affidavit as to why this person is applying, that there is no spouse, there is no family member. The only person applicable is a child. However, the child is unable to do so for a mental reason.
Thank you.
Not a problem. Maya, I think there are 2 questions in the chat.
There's 3, but I saw GL has his or her hand up. You want to go ahead, Giali?
That the local insurance industry in Trinidad may not be as advanced or as adaptive as some of us would like it to be. And I fully appreciate as well your statement in the beginning that unless it happens to somebody in authority, it's not going to change. Having said that, as I understand, you work with, or you're affiliated with Genesis, which is company affiliated with Eon. My question would be, would there not be the possibility of either, and again, I'm not trying to get too technical here, but either a captive insurer or even offshore insurers who may be able to offer such service to the group? Because at the end of the day, yes, we support autism is an NGO as compared to your referral to the law association, but it is still a group of persons. So on a group basis, they still form a population on which it can be priced. And again, not to get too technical, but the same applies to, for example, the mutuals or a captive entity. Again, it is just to find a solution, because as you rightfully said, there is nothing available for those children now. And yes, when you get them onto the plan from birth, it's because they have not been diagnosed yet. So this is why they are not declined the coverage, because it was not declared. It was not declared because it was not existing, or it was not existent at the time of inclusion. So now to try and get them and say, okay, can I get a health plan for my son? And you have to declare in the form if he has any pre-existing illnesses or conditions. Yes, you complete that and say, yes, he's autistic, she's autistic. And this is where they will say, okay, well, sorry, is either no, or we're going to charge you some exorbitant rate, or we're going to impose some exorbitant deductible, which makes it nearly impossible or unapproachable to take the plan or the policy. So again, I didn't mean to make the question so long, but in short, is it the possibility that we can get offshore carriers to offer a product?
Hi, Ms. Ali, those points are excellent. So offshore insurance or US dollar insurance for now, they would offer coverage to kids with autism or parents who enroll in children onto these plans. The thing is that one is in US dollars, which is a problem and a topic all by itself. And two, it needs to be part of, it comes back to being a group health plan. So basically, we have a plan like this in Trinidad that offers coverage to kids with autism, but it's in US dollars and it's part of a larger pool of employees that form a very large entity, right? Because basically they would ask like 5 simple questions, and the 5 questions is like have to do with like diabetes and surgeries and whatnot. So a child with a parent who has a child on the spectrum can easily answer all the questions accurately and still get covered, and then claim for your autism and your therapies and whatnot like that, right? The problem though, like I said, and I'll have to find out, it's if they will cover the NGOs, because the pre-existing condition is not the problem. The problem with the local insurers is that they lump mental disorders and neurological disorders into one, which is, as I mentioned before, grossly incorrect and inaccurate. So that's their issues. But to answer your question, overseas carriers can do a plan, but like I said, the nuance of the US currency and the fact that it has to be a large group would be the issues here.
Just to, and not to take up too much of the time, but just to get one other aspect in terms of the premium, the billing. Again, just referring to your affiliation with Eon, and that you all would have insured local companies and would probably have it reinsured externally. Would the same not apply in terms of local companies paying their premium in TT dollars and then the necessary transfers being done to the overseas companies in foreign currency, whether it be US, pounds, euros, whatever it be, but in foreign currency? Is it not something that Aeon/Genesis can facilitate in terms of the remittance?
Right. So Aeon itself is, their core expertise is in property and casualty. So you're looking at things like a Petrotrain or those plants down in Point Lisas. So what we could do is that we could reach out to them for those kind of markets, but not the health and life markets. You know?
Okay, I get you. Okay.
Yeah. So they would help us with like reinsurance for these large multi-million-dollar properties or whatnot. But in cases like this, that is not where they get involved. So how Genesis and Aeon works, just for some information, is that Genesis core expertise is in health and life administration, whereas Aeon is property and casualty. So when you mix the two, that is why we are able to be a full service brokerage firm and offer every single kind of insurance as much as possible.
Thank you, sir.
Sure.
Hi, one last question.
Sure.
Right. What is required to apply for a group plan if one decides to do that? What is the first step?
You need to be a registered company. You need to have all the things in place like directors and whatnot. You need to be at least 3 people. So a family can't be a group. The group is only offered to business entities with 3 or more persons, but less than 35. To be a small group, and a large group is minimum of 3 people up to any amount.
Thank you.
Sure.
I see Radhika has her hand up.
Yes, and actually I have a question for Denelle. So Denelle, I'm sorry, I was driving and I missed a little part of your presentation, but I just wanted to, I got the part where you talk about the law recognizes a person's chronological age, not developmental age. So in the case of, for example, my nephew Raul, who's 18, but will not be able to function on his own, right? As a what you expect an adult to function at that level. What can I do then to make sure that legally everything is in place for him? So like, is it up to me now, but other than the will, to leave some kind of document stating that he will be taken care of by somebody specifically? What would you advise?
I would definitely advise still do the will, because what document is there that you want to really execute to ensure that he's cared for? You take care of it in the will. So you basically put in, so I'm just using an example based on the circumstances of Raul, is that you would say something to the effect of, I leave monies in this account to be solely utilized for the welfare and maintenance of my nephew Rahul, and you become very specific in your will. And in relation to, let's say, if you're leaving a sole special needs child who does not have a parent or a sibling who is willing to care, but a family friend, have that conversation with a family friend who will be able to step into your shoes essentially to care for your child.
Okay, thank you, Denelle.
Great. So I'm moving on to the questions that are in the chat. Someone sent an anonymous question asking, what's the cost of a will?
It is essentially about, I want to say $1,000 to $1,500. It depends on the attorney you go to, how much time is taken to prepare a will, and the complexity of it. Well, it essentially comes down to how long the attorney spends doing the will. Attorneys charge per hour to do any sort of legal work.
Great. So then we have a question from Bill Thomas. Person says, hi Denelle, in your professional opinion, is it advisable to will all assets to your autistic child? They have only child in brackets who needs help in making decisions.
You won't provide it to them in the will solely, but what you can do, if they're an only child and they need help in making decisions, what you can do is do it on a trust. So you leave it for them and in a trust, and that trust will be used, like I just explained, for their use and benefits, for their welfare and maintenance. So that the monies in the group, the house they're leaving, it is for their benefit, but this person will be tasked with assisting them in executing any issues that it has in relation to. So withdrawing money from the bank, essentially.
I hope that answers your question, Abiel Thomas. Next, we have on Nella. She wants to know, hey, what about in the case where the child is a non-verbal autism and is unable to carry about their day-to-day activity without the support of someone else?
It's a very broad question. I'm not sure what it's in relation to. It's in relation to them carrying out the wishes of a will. Is it in relation to their care? I'm not sure.
Do you want to unmute yourself, Nella, and clarify the question?
Hey, I was just asking based on the question right above mine. I was saying, like, in the event that the autistic non-verbal, what would be the procedure? Because I don't think you'll be able to leave the will solely on their name if they can't carry about their day-to-day activities now. They would need someone else.
So what you can do is that the same executor that you have, who you're trusting to execute your will and essentially apply for your grant, you can ask them if they are willing to assist in caring for your child until adulthood. Are we now talking about children who have reached the age of 18? I know my presentation in regards to the appointments of a guardian and the appointments of a guardian with jointly with the surviving parent, that was in relation to persons under 18. If you're now speaking about persons above 18 but are non-verbal, unable to live their everyday life without support, definitely have the conversations with other people who assist in taking care for them to see if they would be willing to continue caring, because it really is going to come down on the willingness of third parties to assist caring for this individual and step into the role that you have been taking on for this child's life. And your assets, when you're leaving it in the will, you could leave it to the child, but you put the explanation that it will be used for their welfare and their maintenance throughout their life. They have ways we can read it, right? Throughout their life interests, but to be managed by this particular person.
Denelle, on that note, a quick question. You mentioned that so legally it's up to 18, but if again you have an adult who is severely autistic, the whole concept of guardianship and even a letter of guardianship would apply to them too and will be placed within the will?
No, the guardianship aspect does not apply to persons above, as in you want to leave someone to be the guardian of a 25-year-old?
Yeah, so if as I said, they are severely autistic, it doesn't apply still because they are 18 and an adult in the eyes of the law.
No, once you're 18 years of age, you are legally an adult. It's the same thing that goes for, I'm using this as an example just to kind of bring it home as an analogy in the aspects of adoption, where let's say you're 20 years of age, you've grown up with a stepfather and your mother, and your stepfather has been caring for you, let's say for 15 out of the 20 of those years, and you now want to, let's just say, give him the opportunity, like, hey, I want my stepfather to adopt me. Unfortunately, because you are over 18 years of age, you can no longer be adopted by your stepfather. It has to happen before you're 18 years old, because that's the concept, that's how the law sees it. It does not account for someone who's mentally under 18.
So just to confirm, our law has nothing in place for adults, nothing legally in place in terms of guardianship and so on for adults with various, autism
Correct.
and maybe other special needs.
Correct.
Thank you.
Hi. Just one quick recap with regards to the point you just made there. So are you advising parents who have kids on the spectrum who might be, let's say they're severely autistic, or they are concerned with regards to their ability to be independent, to apply for guardianship before they reach 18?
No. You're not applying for guardianship before they turn 18. You're a parent, so you don't need to apply for guardianship. I'm saying that if your child is under 18 right now, via a will, appoint a guardian via will, so that upon your death, this guardian now steps into your shoes and will be the person responsible for taking care of your child.
But if the child reaches 18 years old, does the parent have any legal right over that child, even though they are severely autistic?
You still have you mean in terms of what? They're legally an adult, right? You still have parental rights. Yeah, the rights of their parents.
Like to make any kind of decision, any decision that an adult would make, could a parent make it on behalf of their adult autistic child? That's
You-
what I'm asking.
So you're not okay. So you're not asking in terms of planning for your child's future. Okay. Yes, as a parent, because of your child's mental status, you can act. You can still act on his behalf as a next friend. So it wouldn't be as the term legal guardian per se. You will be doing it as a parent because you're still the child's parent. You understand, or am I losing you?
I understand, but it just seems like not a wise thing to do.
What?
Like how the system is set up, that a parent cannot apply for guardianship for their child after they turn 18 if they have some mental disability.
But why?
If the child decides that they want to move out, but as a parent, you know they are not able to do so, could you stop that child from doing that? That is what I mean. I'm pulling out a specific scenario, but the possibility does exist. The child doesn't have the mental capacity to be independent, but is legally old enough to do so because of their age. Could guardianship, or at least the parent applying for the guardianship, cover that scenario?
No, because guardianship is essentially for persons who are not parents.
Okay, well, I'm not sure what you would call it, but whatever it is called, could a parent apply for? I don't know the legal term.
To essentially apply for anything. I definitely say you can give me a call after this. We can schedule something next week, definitely, because I feel like what you're asking me, it comes down to a lot of details, a lot of other factors that need to be considered. So it's not something I can answer and give you a broad overview of it. It's definitely something rather a little specific and requires a little more factors in play. But I have a fair idea of what you're asking.
Now, can I jump in? I think the general concern of most of the parents of autistic kids is that yes, our children will be 18. Well, when they turn 18, they are now legally adults, but they can't make decisions on their own. They can't do a lot of things on their own. So then how much control do we have when it comes to them? I think that's the general thing that most parents are worried about, knowing that you have an adult in the house, but how much control do you have? That are you allowed to make decisions? I mean, legally you say not. So what then are the options?
Your options are, in terms of like what I was mentioning before, something called a next friend, where the court kind of appoints somebody to make decisions on someone's behalf if they are determined to be mentally unfit to do so. But it comes down to an application to the court, and it'll have to be for a specific thing, a specific purpose. So in this circumstance, I'm using an example. If a person who is mentally challenged has to sue for some wrongdoing and they can't do it because of their mental capacity, someone can apply on their behalf, and it's what is called a next friend. So you're acting on behalf of this person. So it can come like that.
Right. So will they consider things like hidden disabilities, autism, and all these other hidden disabilities in that category? I mean, the insurance people are very happy to consider it in that category.
Yeah,
So,
it's something that will have to go to the courts for determination based on each particular scenario.
and
comes down to
absolutely. Yeah, sorry, go ahead.
Yeah, sorry, that's what I'm saying. It comes down to different factors in play.
Okay. So absolutely last question. How would you go about doing something like that? You start with a visit to the lawyer.
Yes.
Okay, thank you.
Because I always say this, and I should have started saying this, is that the legal advice for one person and the guidance that I'm providing today may not apply to your specific circumstance, because your particular circumstance will have a different set of factors that somebody else's would not have. This is just general guidance, but legal advice is essentially given based on the person's scenario and particular circumstance.
Got it. Thank you.
Somebody else has their hand up.
Oh, Nella and Kat has their hands up. So Nella, you want to go first?
Okay, sure. Hi, just a follow up on the response to my first question, right? So you said in the event that the severely autistic child is now an adult and the parent die, they will in the will they would say that they will have to have a third party who is willing to take care of the child, and they will say specifically that I don't want to lie just now. They will say specifically that they're leaving the money solely for the welfare, to be solely for the welfare of the autistic child, right? But usually when it is the children are severely autistic, you cannot leave them alone. So the third party may not be able to work, right? So what will be their stance in regards to that now?
So whilst you can, in your will, make particular provisions for how to care for your child based on your assets that you may have. If your child is legally an adult and you need to talk to people, you need to now take it upon yourself. And that's why I say have conversations with your family members, with your close friends, as to who's going to assist in caring for your child after you're gone, after you're deceased, who's going to care for your adult autistic child. That is not something where the law can step in and appoint somebody and court order somebody to do it. As it comes on us as a community, you as parents, to talk to family members to step up solely out of the goodness of their hearts. But in terms of your assets, that's what I was talking about in terms of leaving the monies in your bank account to your child to be managed by this third party in the event that your autistic adult child cannot function on a normal day-to-day level. That's the circumstance I was talking about. Did I clear that up?
Yeah, I think you did. I see we have Kat. Hand is up.
Danella, I think I want to, on the back of what Radhika and I think Stacy was saying, you're saying that, I'm just seeking clarification, okay? What you're saying is that there's nothing in law where a parent of an adult who has autism can go before the court and say, I want responsibility for their decisions. It's on a case-by-case basis. And you gave the example, which is very helpful, of if that adult person with autism has to sue somebody, then you can go before the court and say, I will take on this case with suing. But generally, there's nothing in law that says that where you can go and say, I am essentially this person's right hand person because they're over the age of 18. Am I correct in what I've just said?
Yeah.
Yeah?
Apply for something called a next friend and you say that you are responsible for this child. I've never come across a circumstance where persons have had to make a direct application to the court for said circumstance, because usually people tend to understand a bit like, okay, this person is not of sound mentally mind. I am the person's parent, the child's parent, so I can act on their behalf. Usually it works.
Yes, in my experience, it works, but the others asked that question, and I just wondered if
Comes down to a case by case scenario based on different factors as to the why you want to do it.
yeah. Okay, thank you so much.
Awesome. So if anyone has any more questions, now is the time to do so. If not, I want to encourage Ms. Singh and Mr. Daniel to please put their contact information in the chat once again. I would like to say thank you so much to Ms. Singh and Mr. Daniel for taking the time out of their busy Saturday afternoon to be here with us. We really appreciate it. I also want to say thank you so much to all the participants for attending this session. I hope the session was beneficial to you. I know it was to me. I have recorded the session and it will be uploaded to YouTube during this upcoming week, so you can always have access to it. Thank you all so much once again. Have a wonderful Saturday evening and see you all soon. Bye.
All right, everybody, bye.
Take care, everyone.